Okay, let's talk about who can file a mechanics lien and who can't. In order to file a mechanics lien, your claim has to be in excess of $500. And frankly, usually you're probably not involving a lawyer if your claim is less than $500. And realistically, from a practical standpoint, it's better to just let it go. Don't throw good money after bad. But let's say you have a larger claim and you do want to file a mechanics lien. This is, again, typical. There's some exceptions, so you always want to consult with a lawyer before taking any action on your own. And again, situations are fact specific, so don't just go and run doing something because I told you on a video that that's what typically works. But a contractor can typically file a lien without providing any notice to the owner because the owner already knows that the contractor has a claim against them, that they are planning, that they haven't been paid, and that they're probably planning to do something to collect the money that they're owed. A subcontractor, on the other hand, has to provide 30 days notice to both the contractor and the owner of their intent to file a lien. What is the purpose of this? The purpose of this is so that an owner who has no idea that a subcontractor is even working on their property has an opportunity to determine whether or not some money is owed that they have not paid or that they have paid. And there's another carve out for a subcontractor. And the carve out for the subcontractor is if they performed work on a residential property and the contractor themselves were paid in full by the owner, and the residential property is owned by the owner to either live in or rent out, the subcontractor actually can't file a lien against the owner and against the property because their claim is really against the contractor because the contractor has been paid in full. So as for the contractor could pretty much file a lien as soon as they know that they're not going to get paid. As far as the subcontractor, they have an added step of providing an owner with notice so that the owner can respond potentially and say, hey buddy, I paid the contractor in full. This is my primary residence. Leave me alone. Go sue the contractor for your money. Practically speaking, when you're doing these types of things, you want to give people the notice because typically people want to resolve things before spending money on a lawyer and before going and running to the courthouse because running to the courthouse just creates additional delay. So as a practice tip, or as a way to try to get paid quicker and cheaper, I always tell people, even the contractor, to give the owner notice of their intent to file a lien, because that'll give the owner at least 30 days to somehow respond and potentially settle it.